So here's our theme for the day. I always get the opportunity to speak right after lunch when everybody's in a food coma. So here's what I'm going to say. Can't we all just get along? That's the theme for the day in my remarks to you today. My subject is tips and traps for the creditor's attorney in bankruptcy. For those of you who don't know me, I had a pretty active creditor's rights practice for a long time, including collection and bankruptcy. And over the years, I have found that one of the reasons I like to practice bankruptcy law as much as I do is because the bar gets along very well. And so part of what I want to do today is impart my 30 plus years experience in doing this and give you some tips and traps on how to get along with the debtor's bar. So one of the things that I've done, as you see in my materials, and we'll get into here in just a little bit, is I've broken up the subject into the 7 deadly sins. And we'll go through each of those. We'll go through sloth, we'll go through greed, we'll go through pride, we'll go through anger, we'll go through lust, and show you how, through the collection process and bankruptcy practice, how to avoid those deadly sins. So one of the first things that I would impart, how many creditors attorneys do I have in here? How many debtors attorneys do I have in here? Okay, on the creditors attorneys, how many of you do collection? All right, here's your first tip, if you don't already do it already. When I say the word scrubs, I'm not talking about what you wear in a hospital. I'm talking about what you need to do in order to make sure that you don't violate the bankruptcy stay and to make sure that you don't violate the Soldiers and Sailors Civil Relief Act. There are companies out there that where you can, or you can do it on an individual basis, where you can go through and you can take an account, and usually you have enough information, social security number, partial social security number, name and address, and you run it through to see if that person has filed bankruptcy or to see if if they're in the military service. So the question is, when do you do those? And the answer is always. If you look at page E6 of your materials towards the top, I give you when I think that you ought to do those scrubs. If you get a new file from a client, you do a scrub. What's the last thing you want to do? You want to spend any time and money investing in a collection suit when the person's already filed bankruptcy. And if you got 2 consumers, make sure that you run it on both of them. We'll see a case later, what happened to somebody when they didn't do that. So when the case comes in, before we send out a validation letter, the validation letter under 1692G of the Fair Debt Collection Practices Act that you have to send out with your first communication with the consumer. Even after that, before we file that lawsuit, we scrub again. And then we filed the lawsuit, we're getting ready to move for judgment, we scrub again. We've gotten the judgment, we're getting ready to issue any kind of execution. Every execution, we're going to do a wage garnishment. We'll do a scrub. We go a couple years later, we find out that maybe they have an interest in real estate and we're going to file a notice of judgment lien. We do a scrub. Anytime you do any kind of execution, you always have to do a scrub. And you need to have these procedures in writing because you're going to have clients that are going to come in and do audits. They're going to want to see your written procedures. The CFPB, if you're unfortunate enough and you're large enough to have the CFPB actually come in and do an audit of your processes and procedures, if it's not in writing, it doesn't exist. If you have written process and procedures and you make changes to those procedures, you need to have the ability to go back and say, on this date, this was the procedure, it was changed, here's a red line version of it. This is what it was like after the change, and here are the people in management that approved that change. All the way from beginning to end. If you don't have that, let's just say you do have it, because everybody in here is going to do that. So if you do get in a situation where you make a mistake, and it's going to happen, and we all do, and you go in and you can demonstrate to a court or to an administrative body that you have written processes and procedures, the chances are you're going to come out on the better end of that situation. So now that we've done our scrubs, let's start talking about the sins. And I'm on page E7. You can see I got a little graphic there. I kind of like Disney. I had my young girl's 22 now, but still like the Disney. Anyway, so we're going to start off with sloth. And this is an example of what you need to do once you understand that that consumer, that person has filed that bankruptcy. I'll give you an example in the materials, and all the examples I have in here are cases from the Eastern District of Kentucky, some with Judge Scott, most of them are with Judge Wise and Judge Schaff. But I talk about the Canary Clay case. And the facts of it are worth going over. So there was a Chapter 13 bankruptcy was filed the day after the collection attorney had mailed the summons and complaint to the court. Happens all the time. The day after the consumer filed, the consumer's attorney called the collection attorney and said, hey, filed bankruptcy over here. So, and 2 days after that call, the state court action, the collection case was filed and docketed. So it's probably one of these situations they put it in the mail, went to the clerk's office, they filed the suit, and they docketed the suit. And a bit after, 2 weeks or so after the collection action was filed, the debtor was served with a summons. Okay, can you see the problem already? You get a phone call telling that you filed bankruptcy, and the summons gets filed a couple weeks later. So what do you think happens? Well, there was a lawsuit filed, or not a lawsuit. Actually, there was a motion filed in the bankruptcy court claiming they had adversary proceeding, claiming they had filed, had violated the automatic stay. Everybody knows that with violations of the automatic stay, you're usually looking at a adversary proceeding, and if it's a violation of the discharge junction, it's usually a motion for contempt of violation of the discharge order. So that was filed. So here's what I did in my shop, and I want to do that before we go into the bullet points that I've got on E8, where the Judge Scott actually went through and had some very excellent comments in the opinion. But if you're the creditor's attorney, when you get that first phone call from the consumer's attorney, hopefully they're calling you and say, I filed, here is the case number. And you can go on Pacer and you can check it right away. The frustrating thing as a creditor's attorney sometimes is I will call somebody and they say, either we filed or we're getting ready to file. Give me a case number, okay? I'm going to go on, if you tell me you filed, I'm going to go on to Pacer and check. I'm going to hopefully have enough of a social security number, address or something. I'm going to check, and I'm going to put in the notes in my file, talk to the consumer's attorney, said they filed bankruptcy. I went on Pacer, I checked my social security number, no bankruptcy filed. Because as we all know, unless until that bankruptcy is filed, then I can keep on going, and that's what I'm going to do. But if I do find that bankruptcy's been filed, you have to do everything humanly possible to stop that action right then and there. In this particular case, and it's you go back and you do this long enough, and a lot of it's 2020. But in this particular case, certainly what should have happened are the things that Judge Scott talks about in the middle of E8 in your materials. So what Judge Scott said, the creditor's attorney could have filed a motion to annul the automatic stay. We all know that when you go through and you read that section of the code, it says you can annul and terminate or modify. And annulling the automatic stay, as we probably all know, gives that stay, actually you have nunc-pro-tunc effect, or basically you can undo a mistake that you made if the court will go ahead and sign an order annulling the automatic stay. A plea and abatement and bankruptcy can be filed. If you go through the civil rules, you can see that's one of the defenses that you can have, that a bankruptcy has been filed. And what Judge Scott points out is either the creditor's attorney could have done it. Why didn't the debtor's attorney do it? Debtor's attorney could have done it as well. So then Judge Scott takes us all in, and he's looking at, okay, there has been a violation of the automatic stay. I'm going to find that was a willful violation of the automatic stay. And now we're going to look at damages. So the consumer's attorney asked for $10,000. And Judge Scott noted that was probably roughly twice the amount that the creditor was trying to collect. And you can read some of the rest of the commentary in there, but the record shows that there was no communication by the debtor's counsel with the creditor's counsel until after the adversary proceeding was filed and served. There was that initial phone call, but nothing after that. So I put at the very bottom there, you can see, hint, hint, give us a call. That's the only thing that I ever asked as a creditor's attorney. If we made a mistake, give us a call. If you make a call to us and we don't do anything about it, shame on us. If you go ahead and file an adversary proceeding and you don't call the creditor's attorney or call me, shame on you. And that's what I said. Remember what our theme for the afternoon is? Can't we all just get along? All right? We're going to come back to that. And again, at the bottom of page E8, I go into the processes and procedures that you have. So now we talked about people that are a little bit slow on the uptake on what they need to do when that bankruptcy's been filed. So let's talk about the next sin, and we're going to talk about greed. And what we're talking about when we're talking about greed is the In re Jones case. It's on page E9 of your materials. And this really gets back to the difference between in personam and in rem relief that you have usually in a civil action. And I always tell everybody there's two bundles of sticks. I got the in personam bundle of sticks. That allows me to collect on the note, the money. And I got the in rem bundle of sticks, and that's what allows me to get my collateral back. Well, this particular case was kind of interesting. You have a consumer that files a Chapter 13 bankruptcy and includes a mortgage debt. This came as a surprise to me, but as I talked to some of the other debtors' counsel that I know, really wasn't a surprise to them. The plan was served on the mortgage creditor. It proposed that the debtor would surrender the property. The plan was confirmed, and it was completed in about 2 years. The debtor got their discharge. The amazing thing to me is about 9 months later, now 9 months after they got their discharge, which was 2 years ago. So you got a mortgage creditor that's not even seeking to foreclose for 2.5, 3 years. The mortgage holder filed an action in the state court, and they made a mistake. Not only did they ask for in rem relief for the foreclosure on the mortgage, but they also asked for a personal judgment against the debtor, that personal obligation having been discharged in their successfully completed, confirmed, completed, and discharged Chapter 13 bankruptcy. The debtor's attorney filed a motion to reopen the bankruptcy to seek an order of contempt against the mortgage creditor for violation of the discharge injunction. And about a week after that was filed, the mortgage holder's attorney contacted counsel for the debtor to try to resolve the matter. Now, why it took a week, I don't know. If I'd have gotten that motion, it had taken me about a minute to call the other attorney and try to get the thing worked out, but it didn't. Here's kind of the twist in the case, and I'm not pointing a finger at him, I'm just reporting facts here. The debtor's attorney made an initial offer of $4,000. That same day, they withdrew their offer of $4,000, and the offer went up to $25,000. Don't think that that didn't catch the judge's attention when they got to the issue of damages. And thus, I put it under the section of greed. The court found that there was a willful violation of the discharge injunction. At the bottom of page E9, it goes through the elements that you look for to determine whether that was a willful violation. You have to show, one, that there was a violation of the stay occurred. That's pretty easy in this case. That the violation was committed willfully, and we all know willful is easy. You did it, and you meant to do it. There's no intent that you meant any harm. There's no intent that you meant to violate the stay. It's simply the fact that you did it. And that the violation injured the individual seeking the damages. It's pretty easy to prove. So when they get to the hearing, and they get to the hearing on damages, the debtors sought damages for $100 for lost time, and the damages, the attorney's fee that the debtors' attorneys went from $4,000 to $25,000, now back down to $2,047.50. I'm on page E10 of your materials towards the top. So Judge Wise looked at the situation. He said, well, you're not going to get any damages for lost time. But the award for the attorney fees were allowed. And much like Judge Scott in the last opinion we talked about, Judge Wise had some really, really good advice for both sides. And that's in the bullet points on page E10 of your materials. Number one, she noted that the debtor's attorney allowed several weeks to lapse after the foreclosure was action filed before we're talking to the mortgage holder. I'm assuming that when that consumer who had successfully completed their 13 and gotten their discharge got that summons and complaint in the mail, it took them about 45 seconds to contact their attorney. But for whatever reason, things can happen. It took the attorney about 2 weeks to contact the creditor's counsel. The next thing is Judge Wise also noted this vacillation between the $4,000 and $25,000, now the $2,000, and she kind of hearkened back to those same comments that Judge Scott had made in the Clay case. On the flip side of the coin, the mortgage holder's attorney didn't contact the debtor's attorney for a week after the motion to reopen was filed. You get that motion to reopen, that's a pretty good idea that the hammer's about to drop. Why even let that motion be filed asking for the contempt? You see that motion to reopen, you see the reason they're wanting to reopen, that should be a pretty good glue you should get on the phone. Now again, in fairness to the creditor's attorney, it might have been a situation where it went right to the creditor and the creditor didn't get it back to their attorney. I don't know, but that's just something that Judge Wise took into consideration. And the mortgage holder waited an additional 2.5 months before making any offer to settle. That probably didn't help him out. So, what are the conclusions when we go through these couple cases? What are the conclusions from both sides? And again, what's our theme for the day? Somebody tell me. Can't we all get along, okay? Let's just talk. You know, if we screw up or something like that, give us a call. I've never done any debtors work, but I got a lot of friends on that side of the bar, and I know what happens. You get that angry call on Friday night, right in the middle of the Kentucky-UCLA game, from your client saying, you told me that you did this, that, and the other for me. I don't care that there's some basketball game on. You got to do something about it, and you got to do it now. And that sort of sets your teeth on edge. I understand that. You call the creditor's attorney, hopefully not during the game, but that following Monday, and you should be doing something to try to get everything worked out right away. If you get that call or email advising a mistake as a creditor's attorney, advising the mistake has been made, start immediately. Do something and chart what you've done, so if you have to go before the court, you can demonstrate that you've made a mistake. I was telling somebody earlier about a situation I had where we had a garnishment situation, and it happens all the time. We'll talk about that in a little bit. But because I was able to demonstrate all the steps that I took and the immediacy with the steps that I took, the judge basically looked at the other attorney and said, what more would you have them do? You know, they can't make in that particular situation, they can't make the employer stop taking the money out of the paycheck. But you got to be able to log everything that you've done. So we talked about being a little bit too slow. We talked about a little bit about too greedy. Now what we're going to talk about is what happens before the fall, and that's pride. And that's at the bottom of page E10 of your materials. Now this was a case that came out of the bankruptcy appellate panel for the Sixth Circuit. And you can see I said the pride goes before destruction, the haughty spirit before a fall. That's my only biblical verse for the day. Okay. So in this particular case, and I guess I need to have a full disclosure, this is the In re Bear case. Mike Farm at the time litigated this case, and it's got some really, really weird facts that's worth going through because there's some pretty valuable lessons to be pulled out of this case. If you're interested in the backstory about Mr. Bear, I'll tell you about that anyway. He was a riverboat captain, and I'll just leave it at that. I don't want any public comments about the rest of it, but it was pretty interesting. Anyway, he had filed his original statement of intent was to reaffirm. When he didn't carry forward on that statement of intent, he filed a motion to redeem, which was sustained by the court without objection from the creditor. Mistake number one. The order sustained the motion to redeem and include a 45-day period within which the redemption amount had to be paid. But what didn't that motion and order have in it? What happens, and this is something that we do when we are asked to defend these, what happens at the end of the 45 days? As a creditor's attorney, what do you want to happen? They don't pay in 45 days, what do you want? You want the stay terminated, right? Wasn't in the order. That was a mistake. The vehicle didn't include a provision in there. The vehicle was repossessed post-petition a few days before the trustee filed the report of distribution and before the case was closed. There are a lot of creditors out there still that think that once that discharge order is entered, that's all they have to have and the stay is terminated. When it comes to property of the estate, two things have to happen. The discharge order has to be entered, and it can no longer be property of the estate. It's no longer property of the estate either A, when an order is entered, stating it's no longer property of the estate. In other words, that's why you see in the motion to terminate the stay, that's why you're always asking for the stay to be terminated and for there to be an abandonment. Or it happens upon the close of the case. And what happened in this situation is that they picked it up after the discharge order, but before the case had been closed. So they were in violation of the automatic stay. The other thing that was interesting, a lot of you are thinking about, well, wait a minute, wasn't there an automatic termination of the stay here by virtue of the fact that the consumer didn't carry forward with their statement of intent? That's the lesson to be learned in this. What Judge Wise found is she disagreed, and she said the filing and sustaining of the motion to redeem effectively amended the statement of intent from reaffirm to redeem. And since the debtor had taken steps to make payment arrangements with the creditor on the redemption, we can argue about whether you can make payment arrangement on a redemption or not, she found that that was sufficient for the debtor having carried forward with their statement of intent. So the two things to be learned by there is you don't have to have necessarily, at least according to this opinion, an official change in that declaration. If there is a change in what the consumer actually does, in this case from a reaffirmation to a redemption, that's enough. And that's why you have to respond to those. The bankruptcy court found, and the bankruptcy appellate panel agreed, that there had been a willful violation of the automatic stay. The issue was, at this particular hearing, the debtor offered no evidence of any kind of damages. And the court found that the actions taken by the creditor were not malicious or vindictive or egregious. In other words, that's why we put it in this category of prideful. Instead, the creditor mistakenly thought that the automatic stay had been terminated. So, lastly, the court concluded that the debtor couldn't stain his allegations that they violated the discharge injunction. Number one, as we all know, there's no private cause of action for a violation of the discharge injunction. Remember, it's an order for contempt. And because there was no evidence to say that the creditor ever tried to enforce the personal liability against the debtor, remember those in personam versus in rem rights, that there wasn't a violation of the discharge injunction and the creditor's rights, the in rem rights to take the vehicle back to actually pass through the bankruptcy. So again, at the bottom of page E11 of your materials, we go through the lessons, and I'm not going to repeat those because we've basically just gone through them. But again, on these motions to redeem, you need to look at the motion, you need to look at the order, and you need to take steps to address any deficiencies like no termination of the stay if that's not, if the redemption amounts aren't paid in. So now what are we going to move on to? We all just got, yes, sir.
Can I ask a stupid question?
I doubt it's stupid coming from you, but go right ahead.
What, you said there was a willful violation of the stay. I thought that the stay automatically turned into a pumpkin when the consumer debtor gets a discharge in the 7th.
Discharge, the stay is terminated to acts of the debtor. But, in fact, it's in the footnote, I think, if you look at the bottom of page, footnote 15, the bottom of page E11, that the stay against property of the estate continues until the property is no longer property of the estate. And so that was the point that I was making. When is the property no longer property of the estate? It is upon an order of abandonment or the closing of the case. So that's why you have to have both of those. And that's, I can tell you, it wasn't, I've been practicing a long time. It wasn't 20 years ago that somebody said that. I said, that can't be right. And I picked up the code and, you had one of those old fecal matter moments, like, oh, okay, I'll never do that again. So anyway, that's why I make that point. Okay. We just got finished with lunch. So what better of the sins to talk about next, top of page E12, than gluttony? This case had to do with a release of a judgment lien, and it was Judge Saft's decision. And the way that he handled this particular situation, I think, is a wonderful way to deal with that. But there was a comment that he made in the middle of the case that I take exception to. So, and I'm going to go over both of them here in just a minute. It was one of these situations, as a debtor's counsel, you run into all the time. a creditor has filed gotten a judgment, and they file a judgment lien of record. At the time that the consumer files their bankruptcy, they don't own any real estate. But what happens? They come in, they get their discharge, they move on, and then they go out to buy a house. How many title insurance carriers out there do you know are going to insure over that judgment lien? None of them, okay? So that's what Judge Schaff addressed. And he said, well, first of all, he pointed out to 11 U.S.C. section 362A5 and said, it can't attach to after acquired property because that frustrates the debtor's fresh start. I agree with that wholeheartedly. And so the bottom line is, if a debtor's attorney comes in and files a motion to avoid the judgment lien and can demonstrate that at the time they filed the petition that they owned no real estate, he will enter an order requiring that lien to be released. What I'm suggesting, if I were the debtor's attorney, I would say that the lien has to be released, and I would have the order prepared in a recordable fashion, saying that that lien is void and as of no moment. And I would take that down to the county court clerk's office, and I would file it in the records, and I would send it to the title insurance company. Now, the reason I would do that goes partially to the exception that I took with a comment that Judge Schaff made, and that's in the middle of page E12. And he said, and I quote, although after discharge, a creditor should voluntarily release a judgment lien that is not attached to real estate at the petition date, which I agree with, there's no guarantee that a creditor will engage in this review. Some creditors will not take the time to address such requests, and others may not understand their obligations. And my point back is, sometimes it's not an unwillingness to release the lien, it's an inability on my part. In this day and age with some of these creditors and buying and selling of debts, I'm often faced with a situation where I'll get a call from Dean Langdon, and Dean will say, here's my Schedule A. We didn't own any real estate at the time. Release the lien. I say, I can't. He goes, why not? And I go through a litany of things. I don't represent that creditor anymore. If I don't represent the creditor, I don't have any authority to do that. If the judge orders me to do it, I'll do it, but I don't have any authority. What if I still represent the client, but the client has taken that file away from me, so I'm no longer representing them as to that case? What if I have a situation where not only the client has taken it away from me, but I go and I call them and say, you really need to release this lien, and what are they going to say in this day and age? Oh, I don't own that anymore. I sold it. To whom? I don't know. Or they tell you who they sold it to, and you call them, and they don't not in existence anymore, and you can't find out who owns the daggone lien and the debt. Or it's a situation where the creditor is just no longer in existence, and it's in limbo. So if I'm not doing debt collection anymore, that's one of the things that I gave up when and not with no tears, when I switched law firms recently. But in the shops that I ran before, and I think most of you know that dealt with me, if you could show me that you didn't have any real estate, your client didn't have any real estate at the time they filed, I'll be glad to release the judgment lien. But just to understand, sometimes I can't do that. On the reverse side, sometimes they will own a piece of real estate at the time that they filed. And depending on the amount of time between the bankruptcy and discharge and to now, possibly there could have been some equity that's built up in the property. And we all know that my judgment lien passes through the bankruptcy unaffected because that's an in rem right. If you can demonstrate to me at the time that the bankruptcy was filed, that if you had filed that motion to set aside the judgment lien, I understand why you don't do it, because your client didn't tell you, and you don't have the time and the money to go out and do a title lien search on each and every creditor, debtor that walks through the door. I'll probably go ahead and release it. You can demonstrate that to me, but don't get upset if I ask for a little consideration, a little cheddar, a little vig, a little money, because I'm going to have to go to my client and say, hey, you should go ahead and release this. They're going to reopen the bankruptcy. If they reopen the bankruptcy, they're going to file a motion. If they file a motion, they're going to win. Why make you go through all that to have to pay the money to reopen? So if I ask you, and I understand that your cost of doing that is a finite amount of money. I'm not going to ask for $10,000. But if I ask for a few $100s, don't get insulted. You tell me to go take a flying leap if you want to, but that's why I'm asking that. Also, at the same time, And this is another one of those practice things that you don't really realize until you get into the situation. If I prepare a judgment lien, I may send the judgment lien to you as the attorney. And they go, why are you going to do that? Say, why don't you just go ahead and file it? Well, here's why. Remember that situation I said where I may not represent the creditor anymore? Okay? It cost me money to file that judgment lien release. If I don't represent that creditor anymore, I don't have anybody that I can get that, I think it's $13, $15. I don't have anybody I can get that money back from. Come on, Canary, it's $13, it's $15. Do it 100 times in a year. Do it 1,000 times in a year. It adds up. So I'll be glad to prepare it. I'll send it to you. Don't get mad at me if I ask you to record it. You're kind of willing to ask me for the favor. I'm glad to do you the favor, but I just want you to know that there is a rhyme or reason for doing things the way we do. Anybody ever had any dealings? I know a couple people with Bill Maypother of Maypother. Yeah, a couple people. Just a real quick story. Bill was famous for sending these memos around. And he sent this memo around and said, nobody on the first floor shall make any adjustments in the blinds on the first floor. We said, this guy's lost his damn mind. I go up to his office. I said, you've lost your damn mind. Why are you sending this out? Everybody's thinking that you're an idiot. Then he tells me the story. Bill was one of these that got in late and worked late. And the office building that we had at that time was on the corner of 8th and West Jefferson. Not a bad place until you go about 1 block west. You go 2 blocks west, okay, not the best part of town. He noticed one night as he was walking around the building, because the way the blinds were tilted, because there was lights on the inside, people from the outside could look and see somebody on the inside. And we had, in particular, he was a chivalrous kind of guy. He said, we have ladies at work at night, and if you can see in the building, I don't want somebody lurking outside waiting for them. Well, that makes perfect sense. Why didn't you just tell everybody that? I don't have to tell anybody why I want to do anything. So once you tell everybody that, it makes sense. Sort of the same thing. If I ask you and I send you that judgment lien release, don't get mad at me. That's my rhyme and reason for doing it. Okay. We talked about gluttony. So let's now go and talk about our next sin, and that's anger or wrath. What's one of the angriest things that you can, and I'm sorry, I'm at the bottom of page E13, the top of page E14. What's one of the worst things that happens after a judgment to a consumer debtor and drives them to your office the fastest? Somebody want to tell me? Who said garnishment? You get the Cupid dial. Okay, garnishment. It could be a wage garn or it could be a non-wage garnishment. And that's what drives you to the office. And this is where we get into with those. And I want to give you a couple examples. So you file, and this is the case I was talking about before. You file the judgment, you file the bankruptcy, and you call me up and say, I filed bankruptcy. I said, you really filed bankruptcy, or is the guy paying you on the installment plan until you really filed bankruptcy? No, I really filed it. Here's the case number. And I go and verify it's the case number. I said, okay, I'm going to release the garnishment. Here's the thing, folks. I can prepare that garnishment lien release, and that doesn't make the employer stop deducting the money. In the case that I had, it was before, anybody practice in the Western District ever? Anybody remember Judge Henry Dickinson? Nicest man in the world. And so I get hauled before the court. And Judge Dickinson looks at me in that kind of rarefied country judge, wonderful air that he had. He said, Mr. Canary, he said, what can you tell me about this? I said, Judge, I'll tell you. I said, debtor's attorney called me on this day. Here are the notes from my system, okay? Very meticulous notes. And the system we had at the time not only had the date that you did it, but had the time that you did it. I got the call at this time. 17 minutes later, I had prepared an order releasing the garnishment. 2 hours later, I had faxed that order releasing the garnishment to the employer. That same day, it might have been the next day, let's say, that next day, I made sure that that order releasing left my office and went over to the court. And as soon as it was filed, I made sure that a copy of that was faxed to the attorney. The attorney stood up, said, money continued to come out of my client's check. And I said, you're right, Your Honor. I said, here is our transaction record. this is where the money came in. Counsel, do you agree this is the amount of money that came out of your client's check? I said, yes. I said, do you see that negative entry there, Judge? Yeah. I said, that's the day that it went back out to the debtor. Mr. Canary, that's the next day. I said, it better be the next day. I said, I'm not very tall, but I got big feet. And the people around here know that if they don't get that check out, that big foot is going to be someplace very uncomfortable in their posterior. So we got those checks out right away. And he said, well, how many did you get? 3. Let me see the transaction record. He went through it. And I think the longest period we took to get the check out the door was 2 days. And the attorney looked at Judge Dickinson. He said, Judge, it doesn't matter. They violated the stay. That money continued to come out of my client's check. And Judge Dickinson sat back and he looked at the other attorney. He says, what more would you have him do? And I said, no. He said, answer my question. What else could he do? I walked out of the court with no sanction against me, not only because we did it right, but because it was documented. Because if you don't write it down, it didn't happen. And if your system that you have in a situation like that will only date stamp it and won't time stamp it, you better be putting the time in your notes. Because I'm telling you, a half an hour can make a huge difference. So that's what happens, and I think that's what you need to do in situations like that. So let's talk about the garnishment lien and when what usually happens. The worst thing that can happen to your client is the garnishment. What's the worst thing on garnished wages that can happen to the creditor? Come on, I know you know. Preference. You're coming back to me and I got to go to my client and say, I took the money out, now they want it back. They can't have the money back. Yes, they can. We all know what it is. If it's more than $600 and it was taken within 90 days of the filing of the bankruptcy petition, they get the money back. What do you get back and how do you calculate the $600? Okay, that's kind of what I want to talk about next. We all know a lot of times if, let's say it's, let's say it's $750. I thought Jim Westenhofer was in here earlier. Is he back there hiding? Okay. A trustee's not going to open an estate for $750. Doesn't mean that much to the trustee. It may mean a car payment or a mortgage payment to the debtor. So what are they going to do? They're going to use Section 522H, and they're going to come through, and they're going to ask for that money back. So if you can demonstrate to me that you can that the money fits within your exemptions, or even if you didn't claim it exempt, send me your exemption schedule and show me that you could have exempted it, because I think that's all you have to show. Not that you actually did, but that you could. And it's less than $600, then I'm going to give you the money back. Certainly, as a creditor's attorney, any money that was post-petition, we all agree you got to give that money back immediately, right? Maybe. And this is where we have the disagreement. When you file that preference action, what is it that you're trying to set aside? Come on. Participate. Let's have fun. You're setting aside a lien. Okay? You have to go look at state law to see when that lien was impressed. Okay? And I really get into that on page E15 of your materials. Okay? You really have to look at state law, because I will tell you, having practiced in Louisville, that the answer in Kentucky is 100% different than right across the river in Indiana. And it doesn't have anything to do with the bankruptcy code or interpretation of the bankruptcy code. It has to do with state law and when that lien is impressed. I can tell you that, let's go with the bad case for the debtors first. Over in Indiana, the way their law reads is that as soon as that garnishment lien is served upon the employer, at that point, the debtor no longer has any interest in those funds. So if that garnishment lien was served more than 90 days prior to the bankruptcy petition, it doesn't matter that you collect more than $600 within that 90 days, because the debtor never had any interest in those funds. Only where that judgment lien is served inside the 90-day period to get the money back. Okay, now we go across the Sherman-Minton Bridge from New Albany, and we come back into Louisville, Kentucky. What's the law in Kentucky? Well, the law in Kentucky is that the lien on the funds is not created until the debtor has an interest in that. And when does the debtor have an interest in it? It's when he earns the money. So I have a lien. It is a continuous lien, but that lien doesn't attach. Remember back in UCC when you talked about when a security agreement attaches? Well, lien doesn't attach until the debtor has earned the wages. So now we go to the situation in, I look at you and you say, you need to give me all this money back. And I said, well, wait a minute. Look at this last check. You want all the money out of that last check? Yes, I do. And I said, well, we're going to divide that check up. And they say, why? I said, well, some of it's owned post-petition. Some of it's earned pre-petition. Any money that was earned post-petition, you get back today. But if I look at the money that was earned pre-petition, and I look at the rest of the money that I collected within that 90-day period, it doesn't add up to $600, so you don't get the money back. Well, so, they said, well, I don't know if I agree with that or not. I said, well, let's think about it. How can you divide that last check up? I'd say, and I got in my materials, I think there's two ways to do it. You can do a straight line method, which is the easy way to do it. You look at the number of days in the pay period. You look at the number of days post-petition, and you look at the number of days pre-petition. So if you want to figure out how much of it was earned post-petition, in your numerator, you put in the number of days post-petition. In your denominator, you put in the total number of days. You come up with a fraction. You multiply it by the paycheck. And that's the amount that's post-petition that I give back to you. And the other amount is the pre-petition that goes into the calculation for the $600. I would tell you as creditors' attorneys, that's not the best way to, possibly not the best, or debtors' attorneys, that's possibly not the best way to do it. Go get a pay stub. Why do you want to get a pay stub? How many of your clients that when they come into you, they're working overtime? Okay, or they're working sometimes overtime, sometimes not. I've had situations where the backside of that paycheck is very heavily weighted because the last 4 days of that paycheck that's post-petition, they were on overtime. Well, if they're on overtime and you can demonstrate to me that that money that was earned in that post-petition period includes the overtime payment, that's yours. I mean, to me, that's easy. And then you take the rest of it and you go through and you do the calculation. So, I take the position, and actually when I'll defend in court, I have defended in court, and I'll defend if I have to again, that you really got to look at the whole situation. Now, what about, we talked about any questions about wage garnishments. Let's talk about non-wage garnishments, usually served on a bank. When does that lien attach? That lien attaches the moment that garnishment lien is received by the financial institution. So if they get it on day one, and they clean out their account on day two, I'm entitled to any money that was in there on day one. I may or may not get that from your client. There's a really famous case in Kentucky. I don't have it cited in the materials, but if you ever want to look up, it's poor boys, I think. It was a really bad situation for the bank because what happened is the garnishment lien came in on day one. It was one of these situations where it was a sweep account. So every night the money got swept out of the account. So at the time that the lien hit the bank, there was $25,000 in that account. When the bank filed the return on the garnishment, they said there's no money. Creditor's attorney said, I don't know about that. Did a little discovery and found out about the $25,000. The creditor got a judgment for $25,000, not against the debtor, they got it against the bank. So those of you, and I know there's at least one of you in here that represents banks, you need to make sure that you educate the people there that when they look at that, you better be time and date stamping when those garnishments are received, because that's when the lien attaches. And before you answer that garnishment, you best be looking at how much money was in that account. Quite frankly, when those come in, you need to do an administrative freeze on that account right away. And I'm sorry that you're, big national bank, and this is in a branch that's in someplace small Kentucky. Doesn't matter. It's the same way with me as a creditor's attorney. I said, well, we're big, we can't get to it. Do you think any judge is going to buy that? No, you got to get to it. So if you represent those banks, they need to know about that. If you come up with a preference situation, and this is the bottom of page E15, don't feel like you got to file an adversary proceeding. What's our theme for the day? Somebody better to answer it this time. Thank you. Can't we all get along? Just make a phone call. Let me know. Send me the proof. Send me the pay stub. Send me a copy out of Pacers showing they filed. The math's easy. We can add it up, and to the extent that you get the money back, it should be given back to you immediately. If you get a creditor that doesn't do that, and then you end up taking them before the court, I just hope I'm not the one representing them. Okay. Here, the last subject, one of the last subjects, is at the bottom of page E15. Now we're going to talk about the sexy sin. We're going to talk about lust. Okay? And this is an area of the law that has always confused me. Thank you. That's about perfect timing. This is an area of the law that has always concerned me, and I've got my comments in here, but unlike some of these other opinions that I have in these materials, I don't feel real comfortable about this one. So if you have a difference of opinion, let's talk about it. That's one of the reasons I put it last. And this has to do with post-petition debt. So you got, and I put it in lust because I say you got Friendly Finance Company, and Friendly Finance Company wants all their money now. Let's say it's a situation, this really comes up in chapter 13s. So, and I can't remember what the form chapter 13 plan in the Eastern District of Kentucky says. I know there's somebody in the room that knows it verbatim, so maybe they can correct me when we get through here or point it out to me. Friendly Finance makes a loan to the consumer and to have some repairs done on their car. And a few months later, they find out that the customer was in Chapter 13 bankruptcy. At the time the loan was made, Friendly didn't know about it, and because the amount of money that was that was involved in the transaction, they didn't even pull a credit bureau report, so they didn't have actual notice, and they couldn't have constructive notice of the bankruptcy because they weren't a creditor at the time. So now the loan falls into default, and Friendly comes to you and they say, "What should I do?" Friendly is you do a little bit of research and you say, well, it looks like it's going to be a 100% plan. So I put it under lust or envy. Some people may say, well, they're in pretty good position. I don't know if they are or not, because I really get concerned about this interplay with Section 1305. So let's presume for argument's sake that the loan qualifies under Section 1305 of the Bankruptcy Code and is a legitimate post-petition debt. The first question that I have is, does the plan provide for the payment of post-petition debts? Okay, arguably, if it doesn't, then that is not a debt that can be provided for by the plan. And if it's not provided for by the plan, some people could take the position that it's not discharged. That's question number one. Let's presume, on the other side of the coin, let's presume that the plan does have a provision. You as the creditor's attorney, are you doing your client a favor by saying, well, it's going to be provided for by the plan. Go ahead, file a motion to allow to file the post-petition claim, and we'll see what happens. Well, before you do that, you really need to take a look at that Chapter 13 plan, because once you do that, if that claim is allowed, you are stuck with that plan. You know what's going to happen? What you thought was a 100% plan is going to be a 2% plan. Or what's going to happen is you're going to get into a situation where sometime along the line, the debtor comes back and asks for a hardship discharge. We've paid all of our secured creditors. This has happened. I need a hardship discharge. If they finally get a hardship discharge, what percentage do you think at that time they paid to unsecured creditors? 0. So now I'm the one, as the creditor's attorney, who's advised my client that's a really good thing, go ahead and file that claim. You're going to get paid in Chapter 13, and your debt's discharged. I think it's kind of a catch-22. That's what the comment that I have in the middle of E16. On the one hand, it appears the debt could be subject to discharge if the plan has a provision for post-petition debts and to allow a proof of claims file. But on the other hand, you got 523A3 that said that type of debt is non-dischargeable. I read Collier's on this. I read cases on this. I don't think that there is an agreement across the United States on what actually happens. So I will tell you, this is a position that I've always talked to my clients about. I said, if you're in for a dime, you're in for a dollar. If you file that claim and that claim's allowed, you're bound by what happens in the Chapter 13. I know what that other provision says, but to me, from an equity standpoint, you're going to have a really, really tough time in front of a judge because saying that you ought to be able to collect that money. Well, it says, I couldn't file that claim. I didn't have an opportunity to file that claim. And you're going to look at the state court judge, and the state court judge is going to say, but you filed the claim, yeah, and you agreed to be bound by that Chapter 13 plan, yeah, get out. I think I know what our bankruptcy judges would do. Get out. So I think you're either in for a dime or in for a dollar. The question then becomes, if you don't file that, then you may still have to put on some of this proof at a state court level to show that your debt should not be discharged. Because you know what's going to happen. You're going to file that lawsuit in state court. You're going to ask for a recovery on that post-petition debt, and you're going to get accused of violating either the stay or the discharge injunction, probably the discharge injunction because you're waiting until afterwards, for having done that. So anyway, last sin in the 10 minutes that I have left in the middle of E16, we're going to talk about envy. There's some white here in here like mine. Remember the old Twilight Zone? To quote Rod Serling, now we're going to consider the curious case of N. Ray Frambles, which is a case that came out of the Eastern District in 2012, and it's a really good example of what happens in the day-to-day practice in collection law, with a little bit of a twist. Debtor's wife purchased a vehicle 2 days prior to a bankruptcy being filed. We'll call him Mr. and Mrs. Mr.'s the one that filed bankruptcy. Mrs. didn't. About a week after they filed their bankruptcy, they filed a notice advising the creditor of the bankruptcy. They entered into a reaffirmation agreement with Mr., and everything looked hunky-dory. Unfortunately, what happened is the lien on the automobile that secured the debt was not properly and timely perfected. And there was an order entered disallowing, or actually setting aside the lien, and the car went back. There was an agreement between the creditor and the trustee that said the lien wasn't perfected. They sold it. They got to share in a dividend, but there was money left over. Now, I know that there's some recent case law that if something like that happens, you can go back into court. You can ask the court to basically disallow that reaffirmation agreement for lack of consideration. Okay? That didn't happen in this case. So in this particular case, there was a reaffirmation agreement that seemed to say that there was some post-judgment liability. Court came back later, even before that case, and said, no, as to him, the debt's discharged. So what happens? The debt, and remember, we got a Mr. and a Mrs. Mrs. is still liable on the debt, right? She didn't file bankruptcy. It's Chapter 7. So the loan goes to a collection agency to collect on it, and for whatever reason, instead of showing Mr. as the primary, they show Mrs. as the primary. What did the creditor do? What should they do? They do a scrub, right? You remember my admonition at the beginning that if you have two people on it, you need to do the scrub on both of them? They didn't do it. They did it on Mrs. because she was listed as the primary, and they didn't find any bankruptcy. They didn't run it on Mr. So I go through the attempt, what happened. There was a call. Debtor answered the phone, said, hey, I filed bankruptcy. I included this debt. Here's my information. Hung up. Strike one. They pulled a credit bureau report on the debtor. It's unclear whether it was on there, but we kind of think it was probably at least in the public records section of the credit bureau report. They called debtor. Debtor called and said, hey, I told you already. I discharged this debt. Strike two. A third call was made to the debtor. He repeated his admonition to them again, and then what did he do? What he should have done. He called his bankruptcy attorney. At the evidentiary hearing on the matter, the president of the collection agency went through everything that they did, And here was the position that the owner of the collections agency took. He said, it's the debtor's responsibility to give me the information telling me that they filed bankruptcy, okay? What do you think the court thought about that? Not much. If you go to the bottom of page E18, you can see in there what the holding from the court was. And I'm down towards the bottom, and there's 3 points that the court made. The creditor could have found out about the credit report through the bankruptcy through the credit report, through PACER, or they could have called the clerk's office. It's their responsibility, and they didn't do it. Again, it was a situation that came up where it was a willful violation. The court said there was a violation. Debtor's attorney asked for $40,000 in fees and costs. Got 5. Okay? Don't be greedy. So the conclusion for both sides is, if they tell you they filed bankruptcy, you got plenty of ways to check on it. And for debtors counsel, it's what we said before, if we call and we ask, give us the information. So my concluding remarks today, besides we all just need to get along, at the bottom of page E19 is vigilance. You as a creditor's attorney need to be very vigilant when you are faced with a situation where there's a possibility of a bankruptcy. Debtors attorneys, you need to be vigilant in representing your clients. In a situation like that, call a creditor's attorney. If the creditor's attorney won't deal with you, shame on them. If you don't deal with the creditor's attorney, shame on you. Thank you. Perfect.